prior to date becoming current in October, what are the things that you guys need to do? Definitely you need to prepare for the 485 application. You need to get in touch with your employer. Last time what happened in October of 2020, a lot of people were not prepared for the adjustment of status. Believe me, Ready and PC was not prepared too. We did not estimate that the priority dates are going to move all the way to January 2015. Not in our dreams. No, we did not imagine it. You can go back to our guessings, it was wrong. It was only 120,000 green cards, that extra green cards that came into starting in October of 2020. Now we are minimum saying that it's going to be 135,000 extra green cards are going to come to the employment based. And what's going to happen is that most of these green cards, if not all of these green cards, are going to go to Indian national, to a little bit extent to the Chinese nationals. Why? Because there's nobody else there. Nobody wants these green cards except Indians and to a smaller extent Chinese nationals. Since there is nobody waiting there, the priority dates are expected, the priority dates are expected to move faster, and almost all the extra green cards in this year, that means starting in October 1st of 2020 to September, the extra 120,000 green cards will go to Indian nationals. And the same thing is expected to happen next year. The 135,000 plus green cards are going to go to Indian nationals. When the priority date, we have 140,000 regular, 120,000 extra that we got in. When it got 120,000 extra, how much priority dates, how much time the priority date moved? For the EB3 though, from 2010, it went all the way to January 1st of 2015. That's almost 4 years it moved. So now we have extra 135,000. Now there are a lot of wild predictions where the priority date is going to move, but it is for certain that the priority date is expected to move. We know that the filing dates are going to move in October of 2021. We need all the people to prepare on. Contact your company. Some of the companies want the 485 application to be done by outside lawyers. Some of the 485 applications are done by the company lawyers. Some of the 485 applications, the company will give an option, hey, either you can go outside or you can go with our company lawyer. Now you need to be prepared. You also need to get your medicals, you need to get your passport pictures, you need to get your birth certificates, you need to get all the relevant documents ready. I strongly recommend don't get the medicals and passport pictures right now because they won't be valid. But for sure, if you don't have a birth certificate, you probably need to work on it. There are alternatives. If you don't have birth certificate, you may have to get a non-availability certificate. You may have to get an affidavits. These will take time, and I want you guys to work on it right now. Now, if you fail, that's okay. If the priority dates don't move, it's okay. You still need your birth certificate for in the future when you get the green card. I would recommend that you contact your lawyer to do the preliminary work, get ready with your application, and try to file the application in October of 2020. October of 2021. Last year though, for example, Ready and PC was not prepared. So what did we do? We just closed the doors. We said we're only going to do our own clients. We are not going to touch the outside clients. And there are a lot of people that couldn't find the lawyers. They find the lawyers who don't know how to fill the adjustment of status application form. Guess what happened? So many 485s were being rejected. Luckily, some of them were being taken back, some of them are not being taken back. They're going to get one more chance, especially if by any chance it's not being taken in October of 2021. But if you miss this filing dates though, there's a good chance you may miss the entire opportunity. So this is the right time to act. And there are some people who are negotiating at this point of time, Emily. Should I go back to the old employer? Should I start working with that company? Should I downgrade right now? Should I not downgrade right now? All these things should be answered at this point of time, not in September. So if I were you, I would prepare with the 485 application, be ready, and once September or October comes in, I'll file the 485 application. Any thoughts from you?
So you mentioned that Reddy and Newman really wasn't prepared for how far those dates were going to move. On top of that, the visa bulletin for October didn't come out until September 25th. So we had very little time to prepare to file in October. We didn't know if the filing dates chart would be allowed to be used in November or December. So we tried to file everything we could in October. Now, we have time. We know this is coming. Is Reddy and Newman doing anything different this year to prepare in advance?
Yes, we are accepting clients right now, Emily, where what we do is that we are taking some advance and we are preparing all the application and make it ready. And once the September comes in, of course, we're going to charge the full fees and file the application. We're accepting the application right now. So that we will fill all the 485 application, I-765, I-131 for the main applicant, and we'll file the 485J supplement, prepare the 485J supplement. And for the dependents, we're going to prepare 485, I-131, I-765, and I-134, make everything ready, check the birth certificates, relevant documents, and we'll also verify to see that if the previous labor certification dates are tallying with the H-1B, and the 485, when we fill the 485 application, we have to give the employment dates, if they are tallying those things. Now, you may ask a question, Emily, what should people do? Because a lot of companies are reluctant to give the entire I-140 petition. That's the reason I kept it in a link for you at the bottom in the Facebook and YouTube, that you can actually go to this link, you can fill the information out. It takes 10 minutes and it's zero filing fees. Get a copy of the I-140 petition. This, you're directly getting it from the immigration. Your employer won't even know. You're directly going to the USCIS, it's called Freedom of Information Act. They are under obligation to provide. Takes 10 minutes, it's free, it's online, the link is provided. Everybody whose I-140 is approved, if you have not filed the 485 application, just get it, it's free. And when you get the I-140 application though, you will also get the labor certification, so that we can look into the dates, lawyers can look into the dates, the job description, titles what were being given. We don't want to contradict any of the information given. If there is any contradiction, you should consult a lawyer. Make sure that the labor certification is tallying with the non-immigrant visa documents. Make sure that your documents that you have are in line to file the 485 application. These are all the things our office is doing at this point of time, Emily, so that we are prepared. And we don't do the same thing what we did in September, October of 2020, because we were not prepared. I mean, all of a sudden, people were just bombarding and, sorry, we have to close the doors. The phones were ringing like heavy. And we did not take any new clients at that point of time. And unfortunately, a lot of people went to the lawyers who don't know how to file the adjustment of status 485 application for the employment based, and they screwed up. Hopefully so, we will do a better service than what we did last time.
All right, so we're offering this ability to prepare in advance, and we're literally going to get the application 99.9% ready to go.
That's right. The only thing
way before October.
Way before October. The only thing they would require in October is, of course, they have to get the employer sign the 485J supplement. That's the main thing. As far as the employees is concerned, I know my clients. They don't mind even if I call them at midnight. Hey, buddy, this particular thing is missing. You didn't send it. They're fine. But the main thing is that they need to get the employer sign the 485J supplement. That they have to do it in September or October, not right now, we can prepare it. That's the main thing that will be left over. Rest, everything is there. It will be prepared, but it cannot be signed right now. It has to be signed in September.
And how do people who are interested in working on this with us get in touch with us?
They can contact us at info@rnlawgroup.com, and then we can give the rest of the details to them. You can, if you're choosing your own lawyer also, it may be right time for you. If I were you, I would like to go to my lawyer and then, hey, I want to prepare for this one. Even if it costs extra, I want to be prepared for this application. I don't want to go to September and prepare for this application. You know what happened in September of 2020? I want to be prepared at this time. Emily, what about the Biden's new thing that came out today. What was this about?
Yeah, this is actually great news for employment base. This is kind of the first thing we're seeing that gives us a little ray of hope, specifically for employment-based immigrants, because we've been talking since Biden took office that we haven't really seen much action. He was worried about the border and worried about all these, the Muslim ban and those sorts of things. So today, the USCIS came out and said they are reversing Trump's policy of non-deference. So prior to Trump, the policy was that if USCIS had issued an approval notice for a particular type of visa classification, and later that same employer filed an extension for the same employee, same facts, then USCIS would defer to that previous approval unless there was some kind of gross error that they found in the previous approval. And it made the process much more efficient and fast and smooth to get those extensions approved. Well, when Trump came into office, he eliminated that and said, nope, we are not going to defer to any prior approval. Every single extension petition has to stand on its own. We started seeing people who had been in the U.S. in H-1B status for 10 years, same company, same job, no changes. All of a sudden now we're getting questioned, is this job really a specialty occupation? Is this guy really a manager? Tell me how he qualifies. They're questioning their beneficiary qualifications after 10 years. So that, in my mind, is one of the major parts of the Trump administration that just messed so many things up, because it created unnecessary RFEs and it drastically increased processing times. So from the time he came into office and did that till the time of COVID, processing times ballooned, the number of RFEs ballooned, the number of denials of extensions. People were getting denied their extensions after years.
20 times than what it was. 20 times extra denials came in, especially in the period of 2018.
Yeah, so today the Biden administration actually reversed Trump's policy. We're going back to the pre-Trump policy where USCIS will defer to a prior approval. Now this is on an extension application where it's the same employer, same employee, and the same facts. So it has to be an extension without change, but other than that, and we still have to provide all of the same documents, but if you were approved previously, we should see much fewer RFEs on these extension applications and hopefully fewer denials.
Especially, I'm very concerned about L1B and L1A assembly. I mean, significant denials on L1B and L1 extension. Going on the same topic, Emily, now USCIS has opened a request right now to have, for us to give suggestions so that the delays can be less. I think so. One of the suggestions they already implemented is one thing is the going back to the old thing and get it. That's definitely the best thing. I would suggest them also to take out the biometrics off. That will save a lot of time in adjudicating the H1, H4, and EAD could be adjudicated at the same time if the biometrics were not there. That will save a lot of time. The second one is that what I request is that the interviews for the 485 application should go back to previous to Trump administration, where employment-based 485s will not be interviewed. It will be very rare where they have some random or maybe some criminal check. They will do it. If they go back to it, that will save a lot of money. A lot of money for the USCIS and a lot of money for the individuals. It's a lot of effort for them to go for the interview. Sometimes take the lawyer. It's definitely is going to save a lot of time. These are the things that I believe. Anything else that you think so that suggest us on that, Emily?
I think those are the main two changes that we saw. And again, this really signals that we're entering a new era. The Trump administration is behind us now. We're finally trying to get back to some normalcy with USCIS and some fair adjudications, and I think this is a good next step.
I also think so that the passport stamping, Emily, could be done here in the United States. And then people of the non-immigrant people right now can't understand what I'm speaking about. We used to be there when I used to practice immigration law in the early parts of, that was in the last millennium, that I was a lawyer in the last millennium. In the last millennium, the way it used to work was that if you come here on a H-1B, and you're extending your H-1B, you don't have to go outside to Mexico or go to India to get the Dropbox. You could send your passport to the State Department. They will stamp it and send it back to you if it is in the same visa category. That's one thing that can save a lot of time. Even though it is a little bit work for the State Department here, why do you want to send the jobs to India, to the consulates in India or consulates elsewhere? Look at the biggest US consulate in the world right now happens to be Chennai, and the second happens to be Cedar Juarez, according to my stats. So if they have all these stampings can be done within United States for an extension, that will save a lot of energy, a lot of money for everybody to go there. Pandemic things are coming, flight delays are coming, people are getting sick and people are dying. That could be one of the things that I would suggest them to do. Mm-hmm. Emily, on the prevailing wages, now what's going on the prevailing wages? When there are alternative wages, which one is the proper wage to go?
Yeah, so starting next week, we have a new prevailing wage request form that has to be submitted. This is used for the PERM labor certification process. Not very often that it's used for H-1B, so this mostly impacts PERM. Up until now, the way that this form was created, it doesn't really give you a way to specify a difference between primary requirements for a job, primary education and experience requirements, and then alternate requirements. Like, for example, if a job normally requires a master's degree and 2 years of experience, but the employer will also accept someone with a bachelor's degree and 5 years of experience, there's not a great way to put that on this application form for the prevailing wage. And the prevailing wages ended up being issued for only the education and experience requirements that were listed first in that application form. Now, starting next week, the form itself, the format of it is changing, and that will allow the Department of Labor to actually issue 2 wages, one for the primary requirement and one for the alternate requirement. And then going forward, your employer will be required to use the higher wage as the wage offer for the PERM process. So that is going to be starting next week. The new form comes out. So this will be impacting prevailing wages issued probably in the next 4 to 5 months, but it is a pretty substantial change from the current process.
And what's going on the student visa? Now pandemic is hitting more in especially some of the countries, and what's going on these people who are applying for student visa?
Yeah, this particularly impacts those that are new, planning to enroll in this fall. So SEVP, which is under ICE and kind of governs the whole I-20 CVIS system, they came out with their guidance for what happens when a school is offering only online classes versus hybrid classes versus in-person classes. And all of this came up due to COVID, because normally F1s are very restricted in what types of online classes they can do. The majority of their classwork has to be in-person classes. Otherwise, why would we need this person to be in the US if they can do their whole degree online? They can stay in their home country. Well, after COVID, when all of these courses switched to 100% online, those students that were already enrolled were able to complete the semester, but new students coming in were not allowed to come in last fall if their school had opted for 100% online. SEVP just extended that to this coming fall. So again, if you're planning to enroll in a school and we're planning to come to the US this fall, and your school decides to do 100% online courses, you won't be allowed to come into the US for this year either.
What if I am already in United States on F1? Can I travel and come back if my class is 100% online only?
Yes, you can, because this only impacts those students that were not enrolled as of last March. So this restriction is on new students, those that are current students, where the school is switching to hybrid or 100% online, were allowed to continue their studies and should be able to travel.
I just want to update everybody about the consulate guys, especially the US consulates in India are having a lot of trouble. I know for sure Mumbai is closed other than emergency. Delhi consulate is closed for other than emergency. Chennai and Hyderabad are also only for emergency. I don't know if any of the, if Calcutta Consulate, I don't have an update, but at this point of time, it may be, even if you have a drop box though, do not travel, please, because they may not honor the appointments. Also, another thing is that there are a lot of people who are going there and getting stuck either with the H-1B. We had cases where people have been stuck in some countries from March of 2020 to right now. They're getting postponed for the for the consulate visas. So please try not to go there at this point of time. Other than the stamping, there's also restriction on the aid travel though. I may not be that expert in that thing, but I see that most of the Middle Eastern flights are getting canceled. So you may only be limited to the direct flights that are coming from Air India directly to Chicago. I think so it comes to New York or Newark area and also San Francisco area. But other than that, mostly I think so it's closed. Even if the flights are there, I mean, every day you have to look into, does my flight allow me to go? And please don't travel at this point of time for the health sake and also for the immigration sake. It's not advisable because we can't even tell when the consulates are opening. Even if you have an appointment, even if you have a date though, they are canceling those appointments. Be careful on those things.
All right. Paul from YouTube wants to know, should I downgrade from EB2 to EB3 right now where my priority date is June 2016? You know, it's really difficult to advise one way or another. So let's just talk about kind of the pros and cons of doing that. Obviously, if you downgrade now and then the EB2 priority date would have become current in October without the need of the downgrade, then you've just wasted that time and effort and money on the downgrade. That is the biggest risk. Or if EB3 with the downgrade still isn't current in October. Other than that, there's not a whole lot of downside to it. And why would you want to go ahead and do it now rather than waiting until October? Do it while there's no rush. You know, immigration attorneys will be better able to serve you right now compared to in September 15th when everyone finds out that they're eligible to file. And on top of that, you saw what the receipt notice mess was last October, where we filed all these applications and we didn't get receipt notices till January, and people were getting rejections not until January or February. Well, right now, if you're filing an I-140 downgrade, you should be able to get the receipt notice in maybe 3 weeks and know that it's taken care of properly. Then you can upgrade to premium while there's not a big rush for it and get the approval and be set. So it's not a bad idea to do it. Just know that the biggest downside is it may not ultimately benefit you in the long run, but at least you've got it in place and then you're ready to choose whichever one happens to be current first.
And there's another thing, Emily, an additional point of doing the downgrade, Emily, is what if the employer is not willing to do? Then you get an idea what kind of employer you have and take a wise decision to do what you want to do. We have noticed that even though we've been telling about downgrade for a long period of time, we have not advocated very aggressively to do the downgrade until the final act, until the dates become current though. We have always told you can always do it later on. But once we saw the rush in September of 2020, that's when we slowly started changing our opinion. Yeah, maybe it's a right time for you guys to do downgrade right now rather than wait until September. It's definitely contrary to what we said before. We have changed our opinion based on it. So you will test your employer at this point of time. Now, surprisingly, initially I thought the big 5 companies, the big 5 U.S. companies in the stock market, we thought they're not going to do downgrade. We thought the big 5 Indian consulting companies that file more H-1Bs here, we thought that they will do downgrading. But when it comes to the truth though, what happened was that the US companies, I don't want to name all of those companies, but anyway, these are good companies, so I'll name them, Apple, Microsoft, all these companies, they did the downgrading. It's the other companies that didn't do downgrading, so that was a good testing market though. So that's another thing that you can evaluate your company, what to do if the company is not going to downgrade.
Karthik from Facebook wants to know, will this policy be applicable to H4 and H4 EAD applications? So I'm assuming you're talking about the deference policy. To an extent it is, as long as it's an H4 extension, not a change of status, and as long as it's an EAD renewal, it should be it should apply to that. But we never really saw a major impact of Trump's policy on the H4 and EAD applications. The biometric policy is what caused this issue, not the non-deference policy.
A lot of people are asking about the final action date becoming current by September of 2021. According to the State Department, which controls the visa bulletin, though, they are estimating that the final action date should become current for EB3 for at least until January 1st of 2014, if not 2015. That is their estimate. And also when it comes to the EB2 though, they are estimating that the final action date should be current up to May 1st of 2012 by September 2021. This is not my statement, this is the Department of State statement though. They are the ones who control it. They have more data than we have, and I'm just telling what they have told us.
Sen from Facebook says, my I-485 is pending. I did not submit my medicals yet. Come October, if the date becomes current, is there an option to carry the medicals with me to the interview, or do I have to submit them beforehand? It will really depend on what USCIS does, because in many cases, they're deciding not to interview and they're actually sending RFEs for the medical exams to be mailed into them. If instead they are going to interview, usually they'll send a notice letting you know, hey, bring your medical to the interview. So it really depends on whether you get that RFE or not.
I want to elaborate more on that, Emily. We've been criticized by a lot of people on YouTube saying that, hey, how can you say that the USCIS has made an official policy of not interviewing on the 485 for the employment based? No, we never said that they made an official policy on it, but when we look into the trend of the way the RFEs have been issued, we are estimating that they have decided for most of the cases not to do the interview at all. How do we know that? Well, from March of 2017 though, we have consistently seen that they have interviewed the USCIS have interviewed the 485 applicants. Starting in late 2020, mid or late 2020, we saw some of the cases not getting interviewed. But starting in the beginning of 2021, and to right now, in the employment based, we are not noticing any interviews at all. We are getting the approvals of the 485 application without interview. As Emily was pointing out, the RFE will tell whether they're going to interview or not. Typically, when we get an RFE for the medical, we do family immigration, we do business immigration. In the family immigration, it's a must, they have to interview. I mean, there's no option there. So when they issue an RFE, when they ask for the medical though, they ask us like this: why don't you can submit the medicals with this RFE, or you can bring it to the interview. That's how they give an option. When it is coming to the employment based, they are not even giving an option. They're telling only one thing: give me the medical. This is the initial document you're supposed to submit. Give me the medical, which is actually what I like it. I mean, I don't want my client to be interviewed, and it's a lengthy procedure. So based on the RFEs that we have received in the past 3 months, I have not received a single RFE on medical for the employment based requesting hey, either you give us the medicals or you bring it to the interview. Not a single one. But when it comes to the family based though, every single RFE on medical tells us to bring the medical to the interview, but not on the employment based, which is actually the very good news for a lot of you guys. If they don't interview, we are expecting the 260,000 green cards can be used by October 1st of 2021. I am hoping that the USCIS will do that. The trend seems to be that they're not interviewing. The RFE seems to be that they're not interviewing. But it's not an official policy at this point of time of not interviewing.
Rohan from YouTube wants to know, what is the process to file EB2 and EB3 simultaneously for the same PERM? And if that I-140 is denied, can we refile it with the same PERM? So number one, your PERM has to be filed for a job that qualifies for EB2. Once you have that EB2 PERM approved, your employer prepares 2 I-140 forms, signs 2 copies of the labor certification, and mails off both applications separately but at the same time. So all of the supporting documents are the same in both applications. One application ticks one box and one application ticks the other box. If you are submitting an original labor certification with one, that one can be filed in premium processing, but the other one is going to be a copy of the labor certification and only can be filed in regular processing. You may be able to upgrade that later. So it's not really that difficult of a process. It's just a matter of creating the same file twice for the most part. Now, if an I-140 is denied, there is the option to refile that I-140 if you think the grounds of denial can be overcome, and you can use the same PERM even if it's expired at that point, as long as the first I-140 was filed within the 6-month window of validity of that labor certification approval.
Arvind has this question. Hey, you're speaking about the labor certification. Are you speaking about the PERM? How to get it? Good question. Arvind, then I'm speaking about the PERM labor certification. It's all the same. When you go to the link that I provided, FOIA USCIS, you request the I-140 petition. In the I-140 petition, there will be a labor certification. That you will get it. You don't have to ask anybody, particularly the labor certification. I know when you contact your employer, they are not going to provide you the I-140 petition or the labor certification. Believe me, I'm a lawyer for the employer. When the employer calls me, hey, give me the labor certification, I'm not giving it to you. This belongs to the employer. Same thing with the I-140 petition. We say the same thing. But you have a right to go to USCIS and request them to get that information. Most of your things, if you are here continuing on H-1B, will depend on your I-140. So that's the reason if your I-140 has been approved, and if it's approved by more than 180 days, please go to the link, request it, you will get it. It will take only 10 minutes for you to fill it out. It will be a very good advantage for you.
Sneha wants to know from YouTube, her H-4 renewal has been pending for a very long time, and she's thinking of going to Canada for stamping and wants to know if that's allowed while the H-4 renewal is still pending. So assuming this is an H-1 extension, an H-4 extension, not a change of status, but an extension, and your spouse's H-1B extension has already been approved, yes, you can travel and apply for the H-4 stamp at the consulate and come back instead of waiting on that H-4 approval notice. No issue with that at all.
Sandeep has this question. My employer filed for H-1B extension while I'm in India. Can I work? Yes, if you're in India, you're working not on H-1B extension, you can continuously work there because you're an Indian national, you can sit down in India and work. The employer can file the H-1B extension. Yes, that's right, they can. But for you to come back into the United States, you still need to get the stamping because your H-1B expired. Most probably your stamping expired too. You have to get the stamping before you come back. Just to update the people that the Dropbox eligibility has been expanded. If your previous visa has expired for less than 4 years ago, you would be eligible for the Dropbox, especially for the B1 and also H1 and H4. They changed, it used to be, it must have been expired within 1 year. Now they changed the rule to within 4 years. Having said that though, please make a note that at this present time though, the consulates around the world are having a lot of trouble in honoring any of the appointments that have been made due to the pandemic.
Srikanth received a prevailing wage determination for his PERM process at level 4, and it's above his current pay. His employer is a large employer and is very profitable, and wants to know if they can still proceed with the recruitment. Is there going to be an issue for the I-140? Whether the process continues really depends on whether the employer is willing to offer you the position at the required higher wage. If they are, then the process can proceed. If they're not, then they cannot proceed with that process and may have to start over. Sandeep from YouTube wants to know if his employer can file for an H-1B extension while he's in India right now. Yes, it is not necessarily an extension of status. The petition, the approved petition, if it's expiring, it can be extended while you're outside the U.S. Your employer has to request consular processing. Other than that, no issues with getting that approval extended so that you can apply for the visa stamp and return later.
P.K. Kumar has this question. Is there a chance 2020 falls under current this October? We both don't believe in Mr. P.K. Kumar, but if you go back to our estimate in August and September of 2020, and if we are wrong in the same way, most probably, if we are wrong again, which we were wrong many times, yeah, there is a possibility, but I am not relying on 2020 right now.
Smita from YouTube is currently on an O3 visa and did the biometrics for the AOS and is planning to get the EAD soon based on her husband. She wants to know if she can start her own company using that EAD without causing her husband to get married to the adjustment of status. Yes, that is an option. You can rely on your EAD and forego the O3 status and not impact your spouse, who's the main applicant. The spouse can continue in the O1 status and does not get married to the adjustment of status just because you used the EAD.
Ramakrishna from Facebook has a question. My company is going through the merger. What's going to happen? Can they file a 485 or do they need to file a PERM? Do they need to file the PERM, I-140 and AOS, or do they can directly file AOS? His priority date is December 2015. Wow. It depends on the merger though. Is it, your company lawyer can evaluate whether you would require only an I-140 or whether you require a PERM. Most of the mergers that we normally work with requires to file one more I-140 without filing the labor certification and then file the 485 if it's incorrect. That's most of the time. There are sometimes the merger happens in such way that the new company has to file from the ground up, from the basic PERM. So that will depend on if the new company will be considered as a successor in interest for the purpose of the immigration, is it a successor of interest? That is a key word that will depend on how the merger has happened. So as soon as the merger has happened, you may want to look into, you may have to consult a lawyer to see how the things will work. If it's a small company, like only like 20, 25 employees, when the merger is happening though, the immigration lawyers also are involved and they will guide them out in which way you can use the old labor certification and then sometimes which way you can use the old labor certification. So it will depend on how the merger happens.
Harsh from YouTube is living in Canada and working in the U.S. on an H-1B and wants to know if he can visit the U.S. for personal reasons and does he need to apply for a B1, B2. Well, first let me say if you're living in Canada, that means you're not working in the U.S. You may be working for a U.S. employer, but you are working in Canada, which means you are not on an H-1B. When you're outside the U.S., you have no U.S. immigration status. If you're going to come in for a personal visit, then you need the correct visa for that, and that would be the B2 visa. You should not come in on your H-1B visa if you're not coming in to work in the U.S. in H-1B status.
Asim from Facebook is asking, how important is the SOC code on the LCA when you're applying for the H-1B? That is the core element of applying for the H-1B. It is something that has to be, it will be considered very, very seriously. If I were to evaluate a particular, if you give me an H-1B petition though, and if you give me only 2 seconds or 3 seconds to give an opinion on it, the first thing that I will look into is the SOC code. That is the basic fundamental thing. Now, there are all other things that I look into it. But if you give me only 3 seconds, that's the one that I will look into to see if the H1 is approvable or not.
Mara from YouTube wants to know, he has an I-140 already approved, and for the same employer, same job, wants to know what happens if he changes to a different work location. Is there any way to avoid filing a new I-140? Well, it depends on if the job that you were sponsored for is moving to that new location, or is that job still available at the old location. Assuming that job is gone at the old location and only going to be available at the new location, the employer actually has to start the process from scratch and file a new PERM, because the labor market has to be tested in the location where the job is actually at. So new PERM and then a new I-140, but you can port the priority date from your old I-140 to your new I-140.
Justin is saying that great to hear EB3 is going to be current, but what time to downgrade to EB3? Well, Justin, I think so. There is a little bit misinterpretation. We never said that the EB3 is going to be correct, though. Although there are some YouTube statements that are getting there where they are telling is that for our other country nationals, the EB3 is going to be current. Not for Indian nationals. We are not expecting the priority date to be current. Current means, present, though. Now, when we use the word current, means for each individual client, the current will be different. So if somebody files a labor certification in 2021, it's different than the person who have filed a labor certification in 2016. For 2016 person, 16% it may be current, but for 2021 person, it may not be current. So there is a little bit misunderstanding on that. But yeah, when it comes to the other countries, other than India and China, we are expecting, it is already current for other nationals though, and we are expecting that to continue until August of 2021, 22, it is expected to be current.
Mina from Facebook has a daughter who filed a change of status from H4 to F1 that was received way back in August. Biometrics were finally done in February, and she wants to know how long will it take to get the approval? Is there any way to expedite? It is taking a long time. We're seeing some cases take up to a year to process. It may be several more months. So the main thing to be aware of is that if her current H4 status is expiring, because either the H1 is expiring or she's turning 21, and that F1 is still pending, she's going to have to file either an H4 extension or a B2 bridge, because she's got to continue to maintain a non-immigrant status all the way up until the time the F1 can actually be approved.
The FOIA link is there in the Facebook and YouTube, guys. It's at the bottom. Just in case if you don't have it, I will put it again. I'm checking it. It is there. It's there in the bottom, guys. I put it there. It's there. I checked it again. The FOIA link is there in the YouTube. I will check again in the Facebook. It's there. It should be there in the Facebook. If not, I'll keep it within 10 minutes after 6 o'clock of Central Time.
Shailesh from Facebook wants to know, what are the options if the new employer has not filed for an I-140 yet and we're not able to go back to the old employer? Priority date is in 2015. If the new employer starts the process now, it's going to take 12 to 15 months to get the I-140 approval. Yeah, you're 100% correct, possibly even up to 18 months. And there's no other option. It means that you would likely miss the boat for filing in October, but it doesn't mean you miss it forever, because at some point that priority date will become current again, either as a filing date or a final action date, and you will eventually be able to file. But unfortunately, you may miss the October deadline.
Amigo from YouTube has this question: can I go to Canada for stamping my expired H-1B visa stamping? Yeah, you can go to Canada. The only problem, Mr. Amigo, is that they are canceling the appointments so frequently. So please be aware of it, and before you embark into the journey, make sure that the appointment is still there for you.
Raj is in L1B continuously since November 2016, has not traveled outside the U.S., so he's on the last part of his visa, the 5-year limit ending in November. Green card is not yet initiated, and he wants to know, will he be eligible for EB1C given the fact that he's in L1B? Possibly. What qualifies someone for EB1C is if the position outside the U.S. was either manager or executive, and you're being offered a position in the U.S. that's either manager or executive. There are some cases where people come into the U.S. on an L1B for specialized knowledge, even though they may have been a manager or executive outside the U.S. Maybe the U.S. position didn't qualify for manager or executive. Maybe now they are going to offer you a manager position in the U.S. and you were previously a manager outside the U.S. That does qualify you for EB1C. And with that priority date being current, you could file the 485 along with it. But you may face some issues in getting the EAD in time to be able to continue working beyond November, depending on how quickly it can be filed.
Emily, this question, I'll face it to you. It's a little bit tough question. I don't want to answer it. What's the chance for second H-1B lottery like last year?
Oh, yeah, that is a tough question. You know, I think that it was too soon to know. I mean, last year we didn't know.
Pandemic was coming.
Yeah.
We know pandemic is there right now. But we didn't thought that the pandemic is this severe. We thought that with the vaccine everything will disappear, but it didn't disappear. I think so there will be second one, but I don't know to what extent. That's my guess. I may go wrong. What's your guess?
I'm going to guess that there might be a second one as well, because I feel that there were a lot of duplicate filings, and people may proceed with only one and or not proceed at all, and due to COVID, and that will open up some other spots.
Rohit is asking the question, what is the process of filing cross-chargeability for the EB3? At what time can I add my wife to the application? Rohit, it's the 485 stage that you need to add your wife. Even if you're not married at the labor certification stage, it's okay. Even if you're not married at the I-140 stage, it's okay. To file the 485, you must be married, of course. The only reason why you're asking cross-chargeability is, I'm assuming that your wife is born in a different country. There's also another cross-chargeability, I'll discuss about it later on. Yeah, so your wife need to be added in the 485 application. I also want to explain what a cross-chargeability is, that if, let's say for example, the main applicant is born in India, but the spouse is born in Dubai, we can claim the Dubai for the purpose, UAE, for the purpose of the cross-chargeability. You may ask a question, the people who are born in UAE might not get the US citizenship. They don't have to get the citizenship. If they are born there, we can still use the cross-chargeability. So if in Rohit's case, for example, he's from India, his wife is born in UAE, but held the Indian passport all along, he can add his wife to the 485 application and then file based on the other countries, not India. So mostly, which will be current most of the time, so he will be eligible for the cross-chargeability in that case.
Mohit from Facebook wants to know, when are we supposed to get the biometrics appointment and the EAD for an EB3 application that was filed in October? We are still getting biometrics appointments for applications that were filed in October. We're also still getting EAD approvals now for applications that were filed in October. Just to the extreme number that were all filed at the same time, everything's gotten delayed. On top of that, the biometrics appointments had a 1 million person backlog for the longest time. We don't know what the backlog is currently, but because of COVID and social distancing, they really aren't able to process as many biometrics as they were in the past. So definitely some delays there, but we are seeing them come through still for applications filed in October.
The question is, can I move to another country after my I-140 is approved and stay outside the country for more than 1 year and come back on a H-1B cap exempt. Assuming that you are already on H-1B right now, and if you leave the country, outside the country, and the I-140 has been approved for more than 180 days and not been withdrawn, you could come back on H-1B without subject to cap.
Sanker from YouTube wants to know, after how many months or at what point of time can we change the company after filing a 485 in October 2021? So that means that you want to make sure you're eligible for AC-21, and that requires you to wait for 180 days after the 485 was filed, and you also want to have the I-140 approved at that point. Once you get to that point where your I-485 has been pending for 180 days, then you're eligible to move to a new employer without impacting the green card. You can take it with you, but the new job has to be in a similar occupation as the one that you were sponsored for, and the new employer has to sign and submit an I-485 Supplement J in order to document that your new job offer qualifies.
Somebody's telling that they have their I-140 receipt notice. Do I recommend them to file the Freedom of Information? Yes. Even if you have an I-140 approval, I still want you to file the Freedom of Information, because you only have the I-140 approval. I don't know when it's been withdrawn. I can't tell it. And I don't know what documentation has been done for the labor certification. So all that information is available when you go online and fill it. Your employer will not come to know that you have filed for this application. So you can fill it, the USCIS will directly send it through email to you, and your employer will not know that you filed this application.
Satej from Facebook wants to know, can an H-1B visa holder change jobs or work for another employer while the change of status is pending after marrying a U.S. citizen? So I'm assuming you married a citizen, filed the I-130 petition and an adjustment of status application, and that's pending. So it depends. If you are continuing to maintain H-1B status and continuing to work for the H-1B employer and you want to change jobs, you have to file an H-1B transfer. That is possible as long as you're still maintaining H-1B status at that time. Your other option is, if you've received the EAD from the pending adjustment of status, you can choose to forego the H-1B status and instead rely on the adjustment of status and use your EAD to work for the new employer.
Any update on the immigration bill? Not much update is going on, especially on the business immigration. Things are at this point of time, both parties are not willing to compromise on the business immigration. Seems to be that there may be a compromise for the dream kids. There's a possibility coming very soon. I think the way this administration is trying to get to the immigration bill is that they're going to be so liberal in immigration that the Republicans will be forced to come to compromise so that there will be a compromise bill. That's the way this administration is trying to go. The way the previous administration was going is that they were trying to make our lives a hell. They almost were pushing us for us to self-deport. But this administration is going completely the other way around. So hopefully, once the Dream Kids thing is out, I think so the next thing will be business immigration.
Yeah, there is a hearing tomorrow in the House Judiciary Committee, Subcommittee on Immigration, talking about, it may talk about legal dreamers, I have a feeling.
Yeah, it looks like there's I have listened to the Vice President speaking with the Republicans on the immigration topic, but not specifically on the business immigration, but in general immigration, they have discussed on it.
Venkat wants to know, I filed my L1 extension last week. As the involved parties are the same, will today's policy deference still apply to me? So I would expect that it should, because most likely the application is going to take some time to be processed. So by the time an officer actually looks at it, Hopefully the policy manual has been updated and officers will be aware that prior deference is allowed again. So it should. Now, if you did yours in premium processing, is that message going to get to every single officer in the next 15 days? Hard to say, but in regular processing, I would expect it should help.
What are the times it's taking for getting the I-140 receipt notice nowadays? We're noticing definitely significant delays. It's not 3 months anymore, but we have seen that it is taking approximately about 40 days to get an I-140 receipt notice. A lot of questions are getting repeated here, but I just want you to point out that we do have a daily Zoom call where I do answer live questions. The link is there at the bottom. You can go and get the details every single day for half an hour. The Zoom call, we have it, and it will be live. I or Emily will be, or any of our office. Mostly it will be me, will be there in there. I'll be answering the questions for you. The link is provided there. And don't forget that if you want to make an appointment, I know that we try to answer as much as possible, but if you want to make an appointment with me, Emily, or any of our talented and well-educated lawyers in our office, you can make an appointment with us at any time at rnlawgroup.com. We have provided that at the bottom. The link is provided there. You can make an appointment. All of our schedules are available online for you to block a time that's more suitable for you.
Amit from YouTube wants to know, how long can a person work outside the U.S. and be paid a U.S. salary? Well, if you are physically sitting outside the U.S., there are no immigration laws that apply to you. They'll only apply to you when you're in the U.S. And so there's no limit from U.S. immigration side as to how long you can continue to work when you are working remotely from your home country.
Thanks for the update. Ramanuj has updated that David Beer from Cato Institute is testifying before the House Judiciary Committee tomorrow at 2:15. That's good. Cato Institute is one of a very good institution for immigration. They really have good educational and study programs. They have in-depth study of immigration. We really like that organization.
Raj from YouTube wants to know, can I move to another country after my I-140 is approved and then come back to the U.S. later? All right.
Thank you, Emily. Anything else?
I guess that's about it for today.
Thank you guys for coming in. The next YouTube and live session will be next Tuesday at the same time.
Thanks for joining.